took an even uglier turn in the form of a brand new court filing by New York Attorney General Letitia James, filed a formal objection in court opposing the $175 million bond Donald Trump tried to post to find somebody who would give him a $175 million bond, was so that while he was appealing the case, he could stop Attorney General James from seizing his property. Well, now, Tish James has filed her opposition, her objection to the bond, and wait until you hear why she is opposing. Court filing is titled Plaintiff's Memorandum of Law in Opposition to the Joint Motion of Defendants, Trump and Company, and Knight Specialty Insurance Company to set aside the exception and justify the surety. In substance, this is Attorney General James saying, yeah, that bond that you filed ain't worth the paper it's written on. And here is what Attorney General James had to say about it. Preliminary statement. The appellate division, meaning the New York Appeals Court, substantially reduced to $175 million the undertaking, meaning the bond, that defendants, including Trump, were required to post to stay execution of this court's judgment pending appeal. After receiving this favorable ruling, rather than select as a surety a large national insurance company licensed in New York, experienced in underwriting surety bonds, and with policyholder surplus far greater than $175 million, Trump chose instead Knight Specialty Insurance Company, KSIC, a small insurer that is not authorized to write business in New York and thus not regulated by the state's insurance department, had never before written a surety bond in New York or, in the prior 2 years, in any other jurisdiction, and has a total policyholder surplus of just $138 million. Defendants and KSIC, collectively movants, have failed to justify KSIC as the surety on this extraordinarily large undertaking for a number of reasons. Now, friends, before I move on to the 3 reasons that Attorney General James gives for objecting to this bond, you heard that KSIC has $138 million in surplus, in assets on hand. And that sounds like a lot of money, but experts in the bond and surety arena say that a company should post a bond for no more than 10% of the assets it has on hand, which means KSIC should only be posting a bond for somebody, if at all, for about $14 million. Certainly not $175 million. Let's not quibble with that deficiency, because here are the 3 reasons A.G. James gives for urging Judge Engoron to reject this bond. First, movants, Trump and Company, fail to meet their burden of establishing that there is sufficiently secure and ascertainable collateral backing the bond. For collateral, the Donald Trump Revocable Trust granted KSIC a priority lien on a Schwab brokerage account held by the Trump Trust that Trump maintains presently has just over $175 million in cash. But pursuant to the agreements governing how the collateral is pledged and controlled, Trump's trust retains ownership of the account and can withdraw funds or make trades in the account unless KSIC objects within 2 business days after receiving notice of the proposed transaction. KSIC does not now have an exclusive right to control the account and will not obtain such control unless and until it exercises a right to do so on 2 days' notice. But that's okay, friends, because Trump makes another promise. If the value of the funds held in Trump's Schwab account dips below $175 million, then the Trump Trust promises to true up the balance by depositing additional funds in multiple permitted forms, including stocks, a promise that is hollow if the Trump Trust does not have the funds. None of that sounds shady. Reason number 2. Second, the court should not rely on KSIC's financial summary attached to the bond as evidence that KSIC has sufficient capacity to justify writing a $175 million bond. That is because, get ready for it, friends, KSIC sends 100% of its retained insurance risk to affiliates in the Cayman Islands, where lax regulations allow KSIC to use the risk transfer to reduce the liabilities it carries on its books in a way that artificially bolsters its surplus, a practice New York regulators have dubbed shadow insurance, and about which they have sounded the alarm. Really? Do you need a third reason? There's a third reason. Third, and I'm going to paraphrase here a little bit, friends, this kind of a bond is appropriate, quote, only if it's satisfied that the insurer's management is trustworthy and competent. KSIC is not qualified to act as the surety under this standard because, here it comes, friends, its management has been found by federal authorities to have operated affiliated companies within KSIC's holding company structure in violation of federal law on multiple occasions within the past several years. For these reasons, the court should deny the motion and require defendant Trump to post a replacement undertaking, a bond, within 7 days of the court's ruling. Okay, friends, let's see. If the fact that the 10% industry standard means that the Knight Rider Insurance Company, the Knight Specialty Insurance Company, shouldn't post a bond for any more than $14 million because of the assets it has on hand, if that doesn't bother you, well, maybe the Trump Schwab account thing does. But if the Trump Schwab account thing doesn't bother you, maybe the Cayman Islands thing does. But if the Cayman Islands thing doesn't bother you, maybe the violation of federal law on multiple occasions within the past several years thing does. Friends, at this rate, it looks like there is a fair chance that while Donald Trump is in that New York courtroom being prosecuted for 34 felony crimes, Attorney General Tish James might be up the street seizing Trump's properties.